it's like any other criminal case. The defense is not represented at this time because it's an investigation at that time. If the case is going to go to court in a criminal context, there'll be a motion to suppress. The defense counsel will have an opportunity to question it, to move to suppress it, and it'll be decided by the judge in the criminal case as to whether it was properly conducted. In every case to this date, from 1978 to this date, in every criminal case that's been brought, the FISA coverage has been upheld by the criminal judge in the criminal case, and every circuit court that has reviewed one has upheld the FISA coverage as properly conducted and warranted under the circumstances. And the Supreme Court has never ruled on the question. Every circuit, however, has now had an opportunity to rule, and every circuit has upheld the procedure. I think for today's purposes, a more interesting question is the Classified Information Procedure Act, because gray mail is still alive and well and thriving, certainly in Washington. I had a lot of experience with that because I drew one of the Iran-Contra cases that went to trial. The first to go to trial was Oliver North, the second was Poindexter. I tried a guy named Claire George. Mr. George was head of operations for CIA. He knew every deepest, darkest secret our country had for 20 years. And every one of them he decided he needed to use in his defense in the trial. The trial was 3 months. He was accused of perjury and obstruction of justice by lying to Congress about the Iran-Contra affair. He had testified in both the House Intelligence Committee and the Senate Intelligence Committee, and in both had made statements that were alleged to be perjurious. I ended up in the course of a year using SEPA to issue 50, what we designated at the time, top secret opinions. All of the information he wanted to use was at least top secret. Those opinions through the course of time have been declassified, so they now constitute a body of law, the classified facts having been excised, but they got us to trial, and I wanted to prove that the courts could use SEPA in a way to get a case to trial. The order you have in your books from Mosawi is very largely the same order that we did in Claire George from the beginning. In North and Poindexter, all the orders had been oral. In George, I did everything in writing. So there's a body of law that developed in George with written instructions about how to proceed under SEPA. And I think in the long run, well, let me tell you the outcome, and then I'll come back to the picture. Trial went for 3 months, jury hung. Trial went for another 3 months with another jury, and December 9th, 92, George was convicted on all counts. December 24th, 92, President Bush, having been defeated for re-election, pardoned him, along with Caspar Weinberger and a number of other people that day. Somewhat muted the message, although Mr. George still owes his lawyer $1 million that he's still unable to pay. So Mr. George's career was certainly over, and there are collateral consequences to Mr. George that he learned about what happens when you lie to Congress, that I think even though he got pardoned, there's still consequences there. But my task, I thought all along, the judiciary has to show that a person in the executive branch who goes up and lies to Congress can be held accountable by the courts and cannot graymail the courts into being unable to try the person. I thought that SEPA gives a judge the power, and I somewhat disagree with what Jay said about the power of the judge. Don't underestimate a federal judge and what they can do. I understand the government makes the declassification decision, but a judge has the power, if you think the defendant needs the information in their defense, to say either provide the information or dismiss the case. That gives the judge some ability to have some say in what information is declassified. And you don't want to speak too arrogantly about that ability, but I think you can make sure that a fair trial can be conducted and that the public has the information that's necessary to show that a fair trial is being conducted. The SEPA procedure lets the judge decide that substitute information for the classified information is appropriate. So Judge Brinkema said, or ultimately the Court of Appeals said, summaries with the classified information are adequate.